Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Wendy W. Berger, Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, and welcome to a session of oral argument. We have 5 cases on the calendar today. 1 criminal case. The criminal case, each side will have 15 minutes. The civil cases will have 20 minutes. We will begin, let me introduce my panel. To my right is Judge Sawaya, and to my left is Judge Edwards. We will begin this morning with the case of Jonathan Ragsdale versus the State of Florida.
Don't you want to take a break or anything?
That's true.
You want to announce that? Take a break?
We will, Judge Sawaya just reminded me, we are going to take a break between the 3rd and 4th cases. So after the Volusia County case, we will take a break and invite counsel to join us in the Lawyers Lounge for coffee. Let me get the clock going. Just remember real quick. How much time would you like for a rebuttal?
Judge, if I could have 3.5 minutes.
Okay.
Thank you.
All right, you may begin.
Thank you. My name is Michael Lambert, and I represent Mr. Ragsdale. I did not represent him at the trial level. He was prosecuted in a 2-count amended information for traveling to meet and have sexual conduct with a child or someone that he believed to be a child, and transmitting a harmful image to a minor, a specific individual known to him to be a child or believed by him to be a child. Mr. Ragsdale put a personal ad on Craigslist, and in doing that, he had to check an agreement that he was at least 18 years of age or older. He was responded to by a person who labeled herself as Abby Shaw with an email address of livelovelaugh at 3693gmail.com. Mr. Ragsdale's request was for a man for a woman. He indicated in there that his age was 34 years. It was responded to by the undercover officer. The response by the undercover officer was...
There were some emails that clearly indicated that the person he was corresponding with was under the age of 18, more or less 14, right?
Well,
wasn't that clearly indicated in some of the...
Well, here's the message said, into younger girls, semicolon, 14, white female. Then the next one, this is not sequential, but the next one that had...
But do you agree with me that there were communications between the two that clearly indicated that the person he was communicating with represented herself to be 14 years old?
I think the number 14 was in there. Mr. Ragsdale said, I'm 34 years old. There's nowhere where she said, I am 14 years old. The number 14 was put in there twice by the officer. The officer said that in her training, she is to put a number in there as many times as possible. But I don't think it is quite as clear as Ragsdale saying, I am 34 years of age. She said in one of them, which was a very compounded question, there were 3 questions and 1 assertion.
What was he supposed to think when the age 14 was inserted in the communications? Well, what does that tell him?
Well, to me, it would tell me confusion when I get 4 pictures of a 27-year-old woman. The adage that a picture speaks 1,000 words. Well, he had 4 pictures of a 27-year-old woman who's...
So the fact that the age 14 was included in at least 2 of the communications was offset by the fact that he looked at the pictures and he thought that the pictures showed that she was over 18?
Yes, and the position, too, is the role-playing on this website. That people, and the officer said that she was role-playing. The judge found that she was pretending while she was on.
But he admitted to the officer during the interview that she represented herself as 14.
Yes, he did, after he was posed with the choice of either you are a individual who hunts down little children and rapes them, or you're somebody who screwed up and made a mistake. If you're somebody who screwed up and made a mistake, you'll acknowledge that she was 14, that she put in there that she was 14. However, up until that time, he repeatedly said, I thought she was at least 18
You're
or
saying
19.
that that was, the basis for that was police coercion.
Yes, sir. Yes. When he began talking, the officer said, how old did you think she was? And he said, well, when I saw the picture, I thought she was 18 or 19 years old. And he was like, come on, and he repeated, I thought she was 18 or 19 years old. Then the officer began with, well, your name is Jonathan Ragsdale. I don't know who you are. You're either somebody who hunts down little children and rapes them, or you're somebody who screwed up and made a mistake, and mistakes are human, and we can correct our
You
mistakes.
think that's coercion to the point
Well,
where that would...
when you're given those two choices, and that's what he was, I mean, it's a very common technique used by law enforcement officers, the maximization and...
Law enforcement officers use all sorts of techniques to investigate and to interrogate. That doesn't necessarily mean the technique is coercive to the point where you would set a statement aside, or grant a motion to suppress. The issue in this case is, was that coercive?
Correct.
I mean, I have a hard time with that.
Well, but his choices were two. And he began out by saying 3 times, I thought she was 18 or 19 years old, based upon the photographs. Then he says, all right, well, either you're somebody who hunts down little children and rapes them, or you're a human being that made a mistake, screwed up, and it's correctable. Which of those two are you? If you tell me that you thought she was 18 or 19, you're that person that hunts down little children and rapes them. If you tell me you thought that she was 14, then you're the person that screwed up and made a mistake.
What did the trial judge think about your coercion argument?
He denied it.
Pardon?
He denied it.
He denied it.
Yes, sir. Yes, sir. And I agree that it comes here with the presumption of correctness.
I can understand why he denied it.
Again, though, going back, Judge, to the communications between Mr. Ragsdale and this police officer, there are just things in there that, to me jump out. When she says that I'm 5'3", 110 pounds, and have an athletic body, I mean, I can't see a 14-year-old talking like that. I can't see a 14-year-old with a moniker of live, love, laugh. I can't see a 14-year-old that says, well, one of these pictures is me in my nightgown. I don't think 14-year-olds talk that way. The state then relies on the fact, well, the officer said that she couldn't meet him that particular day because her mother was coming home at noon, and that everybody knows that people that live with their mother are only juveniles. Well, I think today in our history is probably the first time ever.
Well, that in connection with the age statement of 14 in the communications, I think is...
Well, to me, and I know these are words, but to me, it's a number that's put in there. She never says, I am 14 years old. She puts in there, she says, I don't want to get prego at 14. But that's in between, you don't like my picture? Do you have condoms? Where do you live? And his response was, I like your picture, I just want another one.
But I don't want to get prego or pregnant at 14 is pretty clear.
Well, to me, no, not if you're role-playing. I mean, I don't want to get prego at 14. I mean, you send a picture of yourself and you're 27 years of age, and you send 4 different ones. I mean, to me, this is, like I said before, a picture speaks 1,000 words. So if you're looking at the picture and you're on a website, I mean, 90% of stuff on that website, in addition to being disgusting, is also people playing roles and acting out. And that's one of the...
And cops.
I'm sorry?
And police officers.
Oh, yeah, well, more and more police officers. As the officer acknowledged, they troll that site constantly. Obviously, the people that attend don't actually know that. But again, that's the argument of the defendant, was that it was, just role-playing by him, that the number 14 inserted in there and acknowledged by the officer is in her job just to be placed in there. Again, she never once said, I am 14 years old. she said, you like younger girls? Well, he's 34. A younger girl to him could be a 27-year-old that sends him a picture. He puts in there the number 14, comma, white female. Doesn't say, I am 14, white female. And then, I don't want to get prego at 14. I mean, to me, that you could almost hear somebody snickering as they say that, because it begins with, you don't like my pic. And that's what he responds to. He never once responded to anything about an age of 14. And when he was first confronted by the person he walks up to the 7-Eleven, where he's supposed to meet this person, is the 27-year-old pictured in the photographs that are sent to him. And he walks up to her and says, Abby? And then she asked him to go inside to get something because the officers didn't respond quick enough. But I mean, he goes to the 27-year-old adult female at the scheduled meeting. I mean, to me, I just think that, in these, I know you've seen many of these cases in the past, and to me, this one is just stretching it to the limits. I've seen plenty of them where they actually say, I am 14 years old, are you sure you want to do this? Oh, yes, I do. All right, you're going to have sex with my sister, who's 14 years old. You're going to have sex with my niece, who's 14 years old. To me, those are quite clear. This one's not. It just inserts a number 14 twice. And the one where I don't want to get prego at 14 is inserted in between three questions, and he responds to the first question about the photograph. And again, he told the officer, I wanted more photographs just to make sure that this is the person that I'm communicating with. Because obviously to him, he'd indicated that he's on this site.
Did the jury hear all of this and hear all of your arguments?
Yes, sir.
So they didn't accept your premise that he should have thought that she never said, that she explicitly said she was 14, and that he had every expectation of properly believing that she was over 18. The jury didn't buy that either, did they?
No, sir, they did not, but the argument is...
The trial judge didn't either.
I'm sorry?
The trial judge didn't either.
No, sir, I wouldn't...
And so
that's why we're here.
We're supposed to accept those arguments anyway.
Well, yes, and I think that's what an appeal is about.
All right.
I'll reserve the remainder.
Okay.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. As Judge Sawaya noted, this is an interesting jury argument, but it's not a great argument on appeal. There was clearly sufficient evidence for the jury to find that the defendant believed that this was a child. She mentioned her age a couple of times, said it was, I can't come today because my mom is going to be home. And, when he was arrested, he said to the officer, is she too young? So it's not like this is a case of insufficient evidence. There was ample evidence for the jury to conclude that he thought he was communicating with a child, and that's a crime under Florida law. So if the court has no questions, we would ask you to affirm. Thank you.
Davenport, for being brief. You're right back up again.
Yes.
And you have 4 minutes and 9 seconds.
I didn't even get enough time to get the blood off my face. Again, it's, the fact about my mom coming home, in today's world, there are more adults living with their parents than ever before. And just the language that the person used in the communications, to me, doesn't correspond with a 14-year-old. And again, the issue was it legally sufficient for the judge to allow this to go to the jury? I think, sadly, if we read private communications, anybody reads them, we're offended by them. But yet, when we make them, we never expect that they're going to be put in a public forum. So I just don't feel that for two of the reasons. One, that, this was role-playing, and then two, that when the officer gave him the choice of either you're someone who kidnaps or hunts down little children and rapes them, or you're somebody who made a mistake, that when you're given those two alternatives and you choose the non-criminal one, somebody who made a mistake, that should be used against them. Thank you.
Thank you very much.